Why is the insurance company's denial letter so important to your disability claim? Hi, I'm Mark Whitehead, a board-certified disability attorney and author of the disability help book, Disability Insurance Policies: How to Unravel the Mystery and Prove Your Claim. Long-term disability insurance companies are notorious for denying legitimate claims based on obscure disability definitions contained in the policy. There's no one legal definition of disability. Every insurance company, the Social Security Administration, and the Veterans Administration all have different definitions. After a long-term disability insurance claim is filed, the insurance carrier will either grant the claim or deny the claim. If the claim is granted, the insurance company will begin to pay monthly benefits. If the claim is denied, the claimant will receive a denial letter. This letter is very important because it will list the evidence the insurance company reviewed when making its decision. Who reviewed the evidence, for example, an in-house nurse or a case manager or even a doctor hired as a consultant, or non-medical reviewers. Most major insurance carriers such as Unum, Cigna, MetLife, and Aetna follow this procedure. The denial letter should state the reasons the claim was denied and what medical evidence the carrier needs to prove disability. The denial letter will also give important information for an appeal, including where and when the appeal must be received, the time limits for filing the appeal, and how the administrative appeal should be structured. What are the time limits for filing your administrative appeal? The denial letter will give you the time limits for filing the appeal. If the policy is governed by ERISA or the Employee Retirement Income Securities Act, the appeal deadline is 180 days. Most non-ERISA policies also give a claimant 180 days to appeal, but it's very important to read the denial letter carefully so no deadlines are missed. If an appeal deadline is missed, the claimant will be unable to appeal further or file a lawsuit in federal court to enforce their rights. If the claimant doesn't exhaust or use all appeals available, the claimant will not be allowed to file a lawsuit. As I just stated, long-term disability insurance claims are usually governed under federal ERISA regulations. If a claimant goes through the administrative appeals process and is denied their disability benefits, their only remedy is to file a civil lawsuit to enforce their rights under the policy. This leads to several important questions. The first question is, who can sue? Any plan beneficiary or participant may bring suit to enforce their rights under the plan or policy. This generally means a disabled individual, but in some cases it could mean their spouse, an estate, or an heir. Typically in disability claims, the suit will be brought against the plan or the plan fiduciaries. The second question is, who do you sue? Typically in a disability claim, the suit will be brought against the plan or the plan fiduciaries, often called the plan administrator. Frequently, the plan administrator is the underwriting insurance company. That's the reason we generally refer to the insurance company throughout our ebook when we are speaking about the plan. Occasionally, but not often, the proper defendant is the claimant's employer. The test is who had authority under the plan to grant or deny the disability claim. Most major insurance carriers such as Unum, MetLife, Cigna, and Aetna follow this structure. ERISA-based federal lawsuits are complicated and can't be filed in your local county or small claims court. Always consult with an experienced ERISA attorney before pursuing any legal action. For more information about this topic, check out my free ebook, Disability Insurance Policies: How to Unravel the Mystery and Prove Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability issue. I'm Mark Whitehead. Thanks for watching.